Hello and welcome to episode 78 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Joshua Hawes, counsel with the Canadian Constitution Foundation.
I'm Christine Van Geyn, the CCF's litigation director.
And I'm Joanna Barron, the CCF's executive director.
In today's episode, I'll walk you through a decision by the BC College of Nurses to punish a nurse for her comments related to sex and gender.
I'll tell you about some extraordinary hate crime charges that have been laid against an anti-Semitic individual in Toronto and share my thoughts briefly on the planned deportation of an anti-Israel protester in the US.
And we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, I'm going to tell you about why the CCF is calling on British Columbia's premier to back away from his plan to usurp a truly breathtaking amount of lawmaking power from the legislature using what's called a Henry VIII clause, supposedly to deal with Trump's tariff threats. I'm talking about Bill 7, the Economic Stabilization Tariff Response Act. And what Bill 7 would do is allow the premier at the stroke of a pen to not only make new laws while bypassing the elected legislature that normally debates and votes on laws, but even more worryingly, amending nearly any law already passed, again, at the stroke of the pen in the premier's office without debate in the legislature. It's basically sort of a War Measures Act or Emergencies Act, but with a much less serious sounding name. And if this law passes, then the premier would all he'd need to do to make a new law or repeal an old one would be to say that the law is for one of three purposes, and those are addressing challenges or anticipated challenges to BC arising from a foreign jurisdiction, supporting interprovincial cooperation in reducing trade barriers, or supporting the economy of BC or Canada. And as you can imagine, pretty much any law could fall under supporting the economy of BC or Canada or anticipated challenges. And that's the problem here. It's just so broad. There are actually only two types of laws that the BC government plans to exempt here. And those are natural resource projects and indigenous consultations. So pretty much everything else would be fair game except, rushing through a mine or rushing through a pipeline, which is probably the one thing we actually need to start doing. And it's a really big problem because the vast majority of the people, 92 of them, who were elected by British Columbians to the Legislative Assembly back in October, will no longer get to study, debate, and vote on these legal amendments, which is the whole point of them being sent to Victoria and paid their salaries to be there. It means Cabinet will no longer be responsible to the people of British Columbia. And in other words, it's blatantly violating the constitutional principle of responsible government, not to mention the rule of law and democracy. Instead of being ruled by the legislature that the people elected, it would mean that British Columbians are essentially ruled by King Eby and Queen Sharma, that's the Attorney General, and the rest of them would no longer get much of a say in what could be very consequential legislation. Now, there are some powers in this bill that may be warranted related to interprovincial trade barriers, but this general sort of rule by regulation in response to Trump tariffs is not on. And the Premier Eby, has suggested this is needed because dealing with Trump is like dealing with a natural disaster. But the reality is this is not as fast moving as a natural disaster. If something's a good idea during a trade war, whether it's reducing interprovincial trade barriers or tolling trucks through Alaska, then that can still be debated in the legislature, and the legislature can move really quickly during emergencies. I mean, in the Second World War, the legislature was still meeting and debating laws, and that was a much bigger deal than a trade war. So basically, at best, I think what you could say about this is that this is a really big error by the Premier, who should know better because he's a former civil liberties lawyer. But at worst, it really looks like a power grab. And people have been asking us, is this type of law where you delegate to cabinet the power not only to make new laws on the fly, but also to amend old laws, whether that's constitutional. And what I'll say is this. So laws that allow for amendments by regulation like this, by cabinet decree, rather than going through the legislature, are called Henry VIII clauses. They're named Henry VIII clauses because UK Prime Minister Thomas Cromwell passed one of these laws in the 15th, 16th century to allow that famously violent king, Henry VIII, to circumvent Parliament by, writing a law that said that Parliament is going to view the king's proclamations as if they have the force of a law passed in Parliament. And the king used this proclamation power for all kinds of things. He regulated food prices, for example, and he declared Cromwell himself a traitor after he was killed with an axe. So Henry VIII clauses strike most constitutional lawyers as constitutionally questionable at best because they seem to override our basic separation of powers. They seem to sideline the rule of law. But the courts have said they're not necessarily unconstitutional. So the Supreme Court said in this case from the First World War called Re Edwin Gray that these types of clauses can be constitutional in some cases. And what happened there was basically in 1914, the Parliament had passed a law called the Military Service Act, which provided for conscription. And this included some exemptions, including for conscientious objectors. People, for example, whose religion forbade them from going to war. But in 1917, the cabinet decided the law that Parliament had actually passed wasn't good enough for them, and they wanted to make orders or decrees that, everyone should be eligible for conscription, and they should be able to send everyone overseas to the war. And the War Measures Act, which they had just passed, had this Henry VIII clause in it, which said that they can make orders if deemed, quote, necessary and advisable for the security, defense, peace, order, and welfare of Canada. And they used this to write an order that effectively repealed the Military Service Act exemptions that the legislature itself had passed. And Gray was one of people facing life in prison for refusing to go to war. So his lawyer argued, hey, this is a Henry VIII clause. You shouldn't be able to just override the legislature's law. And they said, this is a separation of powers issue. Under our Constitution, it's Parliament that makes the laws. The governor and council executes them, and then the courts interpret them. And this was clearly the executive making the laws instead. So a majority of the Supreme Court actually disagreed, and they said, no, this is acceptable. Justice Duff wrote that it was very extravagant of Gray's lawyer to suggest that Parliament had delegated to cabinet the, quote, whole of legislative authority, when in fact it had only delegated these powers during wartime and only where they are advisable by reason of war. And Justice Duff wrote, there's no attempt to substitute the executive for Parliament in the sense of disturbing the existing balance of constitutional authority by aggrandizing the prerogative at the expense of the legislature. The powers granted could at any time be revoked and anything done under them nullified by Parliament, which Parliament did not, and for that matter could not, abandon any of its own legislative jurisdiction. So in that particular case, since Parliament had not fully abdicated its powers and it could revoke them, the court found this clause was acceptable. And more recently, this was looked at in the Greenhouse Gas Pollution Price Act reference, the carbon tax case. And the court said, even pretty broad and important powers can be delegated so long as the legislature is not abdicating its role. But this law strikes us as different. This seems to go even further, and it does seem to be a case where pretty much all of the legislative authority is being delegated to cabinet. And, this is not actually a war. Like the War Measures Act was dealing with a much more serious situation. So this seems quite different. And is this unconstitutional? I mean, it certainly feels that way to me. And I think what's obvious here is that it probably is a power grab, and it looks like an attempt, frankly, to prevent the conservative opposition that came within just a few seats a few months ago from unseating the New Democrats by, preventing them from getting any of the spotlight, frankly, in this trade war, since the legislature will no longer be debating and voting on these laws. Joanna was just talking to a reporter about this particular bill, And he asked me, does this remind you of COVID at all? And I thought you and Christine might have something to say about that as the women who wrote the book on the COVID pandemic. Any flashbacks here, Joanna?
Yeah, well, a lot of people forget this, but right at the beginning of the outbreak, and I believe it was still March of 2020, but it could have been April of 2020. And to give you a sense of just how long ago it was, Andrew Scheer was the leader of the Conservative Party, which Sean Spear said to us when he read that first in our book. He thought we made a mistake, but no, that just, time warp. But the Liberals had proposed to pass a bill that basically arrogated the taxing power entirely to them and gave them the power. And I believe the original proposal was through December 2020, which at the time sounded like crazy long time. The pandemic is for sure going to be over by then. Ha ha ha. But anyway, so that they could raise any new taxes without consulting the legislature. And at first, this kind of flew under the radar, but then Andrew Scheer and other people were like, wait, you can't just like bypass the House of Commons and raise as many taxes as you want. And the Liberals, to their credit, walked it back. So that didn't actually happen. And we didn't see any actual Henry VIII clauses, arguably, unless you consider something like the Emergencies Act, which certainly gave the governor and council, aka the prime minister and his cabinet, the authority to make or amend any law in Canada that they saw necessary to deal with the public order emergency. But our argument at the time in the case of the Emergencies Act was we had this whole, extraordinary pandemic. We also have gone through the Great Recession and other things, and we have not had to resort to emergency powers. So there have certainly been attempts. I think it's just like a knee-jerk reaction of politicians to grab more power in situations of perceived or actual emergencies. And so I'm glad to see that there's been a lot of backlash and questioning of this new attempted power grab on the part of BC. I think that you're right that on the one hand, and also, by the way, Alberta brought in their own Henry VIII clause, which was a bit more tailored with their Sovereignty Act stuff. So I think that legally there are some questions, but this does seem extraordinarily broad. And I would argue that it's distinguishable from something brought in explicitly and time limited in war measures. I don't think that the analogy to Trump trade wars really entirely works. But there's no question that there are some interesting legal issues here. Christine, what do you think?
Yeah, honestly, Josh, before I knew you were going to ask about COVID, I didn't know you'd been asked that by a journalist because as you were describing this, it all gave me flashbacks to COVID. And this was actually one of the things we warned about in our book is that if you allow governing by emergency power for all kinds of things during the pandemic, you're going to develop a reflexivity towards emergency powers that will last well beyond the pandemic. And calling a trade war a emergency issue that requires something like this, I think is because we got this muscle memory related to that grew out of the pandemic, that everything was an emergency. We all needed special powers to deal with anything. Our existing parliamentary system that has served us for so long is no longer good enough. We need to give all of these special powers to the executive to move quickly to address things because we're hands in the air. We can't deal with anything. And you actually see this in the United States as well, where everything is suddenly a national security issue. Things that, like, I don't know if you guys are aware of this attack on Paul Weiss, the law firm in the United States. But, Paul Weiss is suddenly a national security threat. Everything is about safety. We need executive orders for all kinds of things. It's
What's the other firm that's actually an outright war? Is it CanLII or something?
Yeah. That one I'm not familiar with, but I have a friend who works at Paul Weiss. So it's really completely insane that this is everything is suddenly an issue of national security. Everything is an issue of emergency powers being needed to deal with things. So I just think that was a really, really dangerous habit that government and politicians began developing at exponential speed during the pandemic. And now we are living with the consequences of it. And it's devastating to our system. So I hate Henry VIII clauses. I think that this one in BC is one of the broadest that I could imagine, and it completely abdicates the role that Parliament exists for. So I look, I don't want to overstate it. Maybe all of this criticism will cause the BC government to rethink things the way the federal government did with those early tax proposals. That would be the best possible outcome. But the idea that it was even proposed is very disturbing to me, and I think is an indication of the current respect that our governments have for the people who elect them, because they don't want to actually answer to those people anymore. I'm very disturbed by this. I'll turn now to something else I'm also disturbed by, which is a decision in a case also from BC involving a woman named Amy Hamm. Many of our listeners are probably familiar with her case. She's a nurse in British Columbia, and over the years she's been openly critical of gender ideology, critical gender theory. She has been critical of policies like bathroom self-identification for trans people, trans men, or trans women in particular, self-IDing which bathroom they want to use that aligns with their gender identity. She's been critical of this for not just bathrooms, but other women's only spaces like domestic abuse shelters and women's prisons. She's been critical of trans women in women's sports, trans medical guidance, pronoun policies, among other things. And look, cards on the table, I have a lot of concerns myself as well with a lot of these policies. I would not necessarily always say things the way Amy Hamm had, although I also admit I read the decision in this case, but I did not read it in extreme detail. So I likely would have phrased things differently than she did in some of these cases, but I think she is entitled to have all of these viewpoints, and I sympathize with a number of them. So the way that she expressed herself, she said that hers is an ideological position. The most widely reported on thing that she did was sponsoring or co-sponsoring a billboard that said, "I heart J.K. Rowling." And Rowling is obviously the famous author of the Harry Potter series, who had at that time recently made some statements defending women's rights and the right to women-only spaces, and about Rowling's own experience as a domestic violence survivor. So that was one of the things that Hamm had done. She also did a number of interviews related to why she put this billboard up. She made a number of posts on X, gave interviews on podcasts, did a public writing, wrote some op-eds. And in some of these posts and in some of these interviews and writings, she was identified as a nurse. Now, the comments were, and the billboard were all referred to the Nurses College, which is the nursing regulator in BC, and they investigated, and the investigation resulted in a 332-page report and was referred to the disciplinary committee. And the college, the nursing college, alleged that her tweets, articles, and interviews were, quote, discriminatory and derogatory statements that constituted professional misconduct. And there was a disciplinary hearing that lasted 20 days, which is quite long. And the college brought in experts to make arguments about, I guess, the fluidity of gender, and experts who view this, who accept this sort of critical gender theory approach that Hamm disagrees with. And then Hamm brought in her own experts who argued for a biological grounding in sex and gender. The disciplinary committee issued their decision recently. This whole process took about 4 years. And the decision is 115 pages long with a lengthy appendix. I think there are 33 tabs of statements that Hamm made that the committee was looking into. And The result was that the panel found that there had been professional misconduct in relation to 4 items where Hamm expressly identified herself as a nurse while making these, quote, discriminatory and derogatory comments. The panel found that describing herself as a nurse in a biography that was attached to 3 articles she'd written and in 1 podcast was enough to create a connection to her profession, which brought her under the purview of the regulator. But with respect to her extensive off-duty posts on X, where she did not identify herself as a nurse, the panel did not make a finding of professional misconduct. They said that they are not prepared to rely on the high-profile nature of her writing or frequent references to her status as a nursing professional, because to do so would effectively prevent her from making any public statements, because that would automatically have a sufficient nexus to the profession. Now, on the billboard itself, the billboard was not one of the items that was subject to the discipline. But what they said about it was the billboard message would convey to a reasonable member of the transgender community that support is being expressed for a view that transgender women may pose a risk of harm to cisgender women and girls. And through the lens of a reasonable person in the transgender community who had read J.K. Rowling's essay, Rowling had written this essay about women's only spaces. The panel also read the essay, and they said it recognizes from the perspective of a transgender person, the essay contains some references that could be interpreted as portraying them, the transgender community, as a risk to cisgender women and girls and predatory. Such characterizations unquestionably elicit fear and hostility towards transgendered people. So the issue that resulted in discipline was not the billboard itself, though. It was the kind of articles about it and about other things where she was identified in the biography as being a nurse. The panel also concluded that because they had these experts on biological sex and then critical gender theory, they concluded that the binary view of male and female amounts to an oversimplification that does not align with current medical or biological understanding. So in other words, they sort of sided with the critical gender theory side of the case. And it went on to hold that Hamm's charter right to freedom of expression wasn't under threat, in part because her words were squarely directed at members of a vulnerable and marginalized group in society. So this really troubles me. The whole thing really troubles me. And there are a few things to remember. As a member of a regulated profession like nursing, you retain the right to freedom of expression protected under the Charter. Now, while off-duty speech can fall within the jurisdiction of a regulator, there needs to be a clear nexus to the profession. And just having an opinion and people knowing that you are a nurse, in my view, is not sufficient. And look, Hamm, the evidence before the panel was that when she was practicing as a nurse, she always used the preferred pronouns of trans people at work, and she has taken transgender-related training. She says that she has kept her political views about these critical gender issues very separate from her professional life as a nurse. So what is the nexus? Like, I just do not think the mere fact that she is a nurse is sufficient. You can't stop being a nurse just because you are not at work. It doesn't matter to me if she identifies herself as a nurse or if she doesn't. She's not, by merely doing so, leveraging her position as a nurse to push a particular medical view. For the most part, these are social and political issues, and there is, a part nexus to medicine, which is the criticism of certain medical practices. So, to the extent that there's a nexus there, this is an issue of debate within the medical profession itself. This is very, very, very far from settled medicine. And it's emerging medicine that is new, and that there is a lot of debate within the medical community about. And the medicine itself is a truth-seeking endeavor, and silencing one particular viewpoint based on the content of that viewpoint will impede the search for truth in medicine. Now, there have been other cases like this. One was a case in Saskatchewan, actually both, I'll mention two Saskatchewan cases, and you'll see why. So there was a nurse in Saskatchewan who protested abortion, and there was an attempt by the disciplinary committee to say, because abortion is a medical service, expressing your opinion and people knowing that you are a nurse expressing this opinion is professional misconduct. And that discipline was overturned. Another nurse in Saskatchewan, it was overturned because that's just not sufficient. Another nurse in Saskatchewan, her name's Carolyn Strom. We were involved in her case, and that case was cited in this Hamm decision. So Strom had posted on Facebook and identified herself as a nurse, and she had posted about criticism she had of our healthcare system, particularly with respect to end-of-life care. And that discipline was also overturned on appeal. And I think it is likely that it was possible to have these decisions overturned in Saskatchewan because the standard of review in Saskatchewan for the nursing regulator is a standard of review of correctness, not reasonableness. And reasonableness is a lower standard, it's more deferential. So it's important to remember that the people who make up these regulators, including Hamm's regulator in BC, these are not experts in constitutional law or in the protections of freedom of speech and expression. These are experts drawn from the nursing profession, and they have technical, specialized knowledge about nursing and standards of care in nursing, and that is good. That's the vast majority of cases relate to technical standards. These people can review things where that technical expertise is relevant, but they have a thin and impoverished understanding of our Constitution, and it shows. Their decisions on matters involving free speech should not get deference, and the standard of review in most places is a deferential one of reasonableness. Now, I have proposed some improvements to the system that I think could help in cases like this one. If it does get judicially reviewed, you can change the standard of review through legislation, and I think that would be an appropriate thing to do, but Parliament would have to do it. And in fact, I made this proposal in a big paper I wrote for the Macdonald-Laurier Institute. And after I made that proposal, the Alberta government announced a plan to look into doing exactly that. So I think this is an important way we can prevent bad decisions like what I think has happened here in the Hamm decision. I don't know what is happening next in this case. I think, she could probably seek a judicial review, but given the deferential standard, it may be difficult. But if she does, I would be open to considering intervening in a judicial review of this. Josh, what do you think?
Oh, I'd be open to it for sure. I mean, these regulators, like the regulator's job is to regulate nursing. It's not to regulate your opinions in every space and every facet of your life. If Amy Hamm was, let's say she's working in an emergency room and someone comes in and they say, I identify as they, them, and she continues to call them he or she, I think that is arguably a problem. I think that is, there's a standard here. Whether you agree about gender theory or not, you should be, kind to people and treat them with respect. And that would be going too far. But we're not talking about that here. We're talking about things that she said in, a podcast or, things that she read. Like, this is very Soviet. It's very, very disturbing attempt to just control her speech and shut down an alternative viewpoint that, frankly, a lot of people have, whether it's right or wrong. And I do understand like the sort of urge to weaponize this regulator to punish her, because there's all these doctors on Twitter right now that are tweeting all the time about Israel, the Israel Gaza conflict, and some of them go really over the line and I think are like kind of brainwashed by Hamas, and I think like, oh my God, I wish, or like I would worry if that was my anesthesiologist. But then I look at it and I say, actually, you know what? They have an opinion that I disagree with. They're still qualified by the college to administer anesthetics, and if I
Well, as
actually
long as they don't
encountered
go as far as the nurses in Australia that say that if an Israeli patient showed up, they would let them die.
Yeah, that would
that's right, but
that's worthy of discipline though.
that is absolutely that's about medicine, right? That's about the practice of medicine with actual patients. It's not about my opinion on a political issue that happens to be tangentially related to nursing practice in the sense that it's tangentially related to everything. So yeah, I hate this. If there's an appeal, I would definitely be down for figuring out what we can assist the court in figuring out. And Christine, you yourself are Canada's leading expert in this at this point, I would say. So I think we'd probably be all in, but I won't speak for Joanna. She's the boss here. So Joanna, what do you think?
I don't really have much to add. Yeah, except that this is really where the clampdown in practical effect on everyday people on speech happens, right? It's true that we see the free speech cases usually testing extreme cases of speech, which I guess I'll get into in a moment. But I have great unease with the proposition that if you're a lawyer or a psychologist like Jordan Peterson or a nurse, that all of a sudden everything that you say in the public square is up for grabs, and anything controversial you say can get you hauled before your regulator. I think that is a very disturbing proposition, and I'm really glad that Christine has proposed tightening up this so-called nexus, because I think it's a huge issue. Like, a huge swath of our society are regulated by some type of profession, and we don't want those people to be muzzled and not able to express their opinions on Twitter or in op-eds. That's just not acceptable in a free society. So let's take a break, and then we'll come back and talk about some actual hate speech. Okay, so we talk a lot about hate speech and some of the standards around criminal charges like advocating genocide and incitement to hate. And we talk a lot about how these charges are very rare and exceptional. But these charges seem to have been laid. We don't have full information yet in a recent incident stemming from allegations dating from last spring until January of this year in Toronto. So this individual, who is a 32-year-old Toronto man named Amir Arvahi Azar, has been charged with 29 criminal counts in what is described as an 8-month-long anti-Semitic hate crime spree. And now it's important to note that we don't have all the information about this. Some of the facts and specific allegations are protected under a publication ban. But what we do know from a press release that the Toronto Police Service put out and court documents, the charges include advocating genocide against Jews, inciting hatred, as well as, and I think this is important because we're not just talking about speech crimes here, multiple counts of property damage and vandalism targeting Jewish institutions. And so the charges stem first from posts made on social media, but also conduct. And these crimes occurred mostly in North York, Toronto, which has a large Jewish population. The conduct started in April of 2024 when he allegedly set fire to a United Jewish Appeal sign. Then 2 days later, he set fire to a sign at a synagogue called Beth Tikva. In June, he threatened the staff of Forest Hill Jewish Center, which is actually a synagogue that I have been a member of. It's a lovely synagogue with a really diverse congregation. He also damaged a window at the Pride of Israel synagogue, which was my grandparents' synagogue. So all of this really hits home. He damaged the window at Kehilat Sharei Torah, which is a predominantly South African congregation at Bayview and York Mills, where I grew up. Then he set fire to a sign at another shul called Temple Sinai, then another one called Tiferet Israel. So he was just like going all around, not discriminating. Like, these are orthodox.
Allegedly.
Pardon me. These are the allegations.
Yeah. No, none of this has been tested in court. That's what the media lawyers get paid lots of money to say every time. So these are all allegations at this point. Yeah.
Yeah, so he is alleged to have not discriminated between secular, Orthodox, pro-Israel, more religiously oriented. He even also is accused of targeting a Jewish-owned coffee shop, and then there are other details which, as I mentioned, are protected under a publication ban. Now, so what has he been charged with? The criminal code contains specific provisions that criminalize hate speech, which we've talked about a lot, but as a refresher, Section 318 prohibits advocating or promoting genocide, and Section 319 prohibits public incitement of hate against identifiable groups. And we've talked a fair bit about this advocating genocide in the context of the Online Harms Act, because the Online Harms Act, in addition to bringing in new offenses for online speech, also proposed to raise the potential penalty for the crime of advocating genocide to reach the potential of life in prison. And these are serious offenses that are rarely prosecuted in Canada. They require special authorization from the Office of the Attorney General. And there's a high threshold required for conviction. So, for the charge of advocating genocide or inciting hatred, the prosecutor has to prove beyond a reasonable doubt that the accused willfully, consciously, intentionally promoted hatred or advocated genocide. But of course, before they get to the point of having to prove allegations, they can, of course, wield pressure on the accused by laying an array of charges which have potentially serious jeopardy, potentially long jail sentences, which can, of course, pressure the accused to reach a plea deal. And we don't know what is going on. There's no way that we could know what is going on in terms of negotiations between counsel for the accused and the prosecutor's office. We do know, though, that he was released on bail. So I want to contrast this, though. There's a lot that we can't comment on because we don't know the full facts and we don't know what's going to happen, just that he's out on bail and he seems to have been accused of what sounds to be a pretty horrific course of conduct, which, of course, has not been proven in court, but it includes both speech and conduct, setting things on fire that clearly goes beyond mere speech to property damage.
And
But I
there
want
were alleged weapons offenses too, right?
I didn't see anything about that, but I could
Okay.
just not have. There's 29 different charges, and I didn't see weapons offenses, but it could possibly be. So I'm not sure. But we wanted to contrast this just briefly with the case that I'm sure many listeners of this podcast have heard about and possibly have a passionate opinion about, which is, of course, the case south of the border of Mahmoud Khalil, who is the Columbia student who is facing deportation and having his green card revoked. And whatever you think about that decision, it sounds like currently his deportation has been blocked by a judge in the US. But it's clear at this point that Khalil is not being accused of specific lawbreaking, unlike this individual, where he's being accused of an array of things that, if proven, would be illegal in Canada. Now, I'm not saying that it would be impossible to accuse him of illegal conduct. Khalil was allegedly a leader of these protests at Columbia that, of course, started about a year ago, that certainly crossed the line from lawful protected expression, even under the much more expansive definition under American law, and crossed the line into harassing students, disrupting classes, occupying Hamilton Hall, not allowing the normal functions of the university to proceed. However, based on what we know now, based on statements from the Trump administration, the sole basis that the administration is positing for Khalil's deportation is that the Secretary of State, Marco Rubio, deemed his participation in these demonstrations at Columbia to be, quote unquote, adversarial to the foreign policy and national security interests of the United States of America. And White House Press Secretary Caroline Leavitt last week confirmed that the issue of actual legal conduct was not the basis on which they were proposing deportation. She said that he's being targeted under this law that allows the Secretary of State to personally deem individuals adversarial to the interests of the US and have them removed. So there's passionate disagreement about this. If you are interested in the issue, I recommend an article by the executive director of the Foundation for Individual Rights and Expression, Greg Lukianoff, that goes through how there are a lot of really interesting and murky legal questions, especially what are the actual due process rights of green card holders. They seem to certainly have some rights and also have the right to free expression, but obviously they have different rights and their residency in the US has different qualifications than US citizens. But um, it is different, and I would say at least preferable in this case, that in the case of this Toronto individual, that there are specific and enumerated and articulated allegations that he is facing. Totally different from the Khalil case. Christine, this is a thorny case, both the Khalil case, less so the case of Azar in Toronto. Do you have anything to add?
Yeah, so I just checked the charges from the news release, and there's a huge. I mean, I have no sympathy for this Mahmoud Khalil, the Mahmoud guy from the U.S. Like zero sympathy at all. He
Yeah.
seems like a really terrible human being.
Mhm.
This guy in Toronto, the list of charges is pretty extensive and goes well beyond speech, right? So there was arson, which obviously is a dangerous crime, but there was also 3 counts of possessing a restricted firearm, knowingly not holding the license. There was possession of a firearm with an altered serial number, possession of a prohibited device, and a prohibited device would be like there's a bunch of different things like a silencer or a certain type of barrel or certain types of ammunition or certain types of magazines that would convert your weapon. So that's what we don't know what it was, but it was a prohibited device. 2 counts of possessing prohibited weapons, possession of credit card data, and possession of forgery instruments. So this sounds like a very dangerous person. So in addition to the allegations of advocating genocide, we don't know what he said, as well as the statements on willful promotion of hatred. Again, we don't know what he said, but these weapons charges enough are highly, highly dangerous charges that he allegedly committed. And honestly, based on these charges combined all of them together, it's just shocking to me that he's out on bail.
Yeah.
Like this is a very seem that if these allegations are proven true, this would be a very dangerous individual. Josh, anything to add there?
Yeah, so just on the Khalil thing, it's really interesting because I think if you're a student and you're on a student visa and you're not a permanent resident of the United States or Canada, I don't think that the state owes you much under the Constitution, and I think that if you're a threat to national security, sort of on a balance of probabilities standard, it should be fine to send you back. And I'm not commenting on him specifically because I don't know what he did. But I do have a lot of concerns here because this guy's like a permanent resident. He's a green card holder, and he's not charged with the crime, and yet he was specifically targeted arbitrarily by the people at the top of the US government, which is just not how this stuff is supposed to work. So I'm all for, deporting students that have proved to be national security threats by revoking their visas. I'm okay with deporting permanent residents if they've actually committed a crime and it's been proven beyond a reasonable doubt in a court. But this is just like arbitrary action, and it's kind of like what we were talking about earlier before, where it shouldn't be a premier or a president acting like they're the king. It should be the law that's deciding whether or not they get to stay in the country. And this just strikes me as arbitrary enforcement and the worst approach to a real problem. So that's all I'll say about that. Maybe we'll move on to our bad legal takes. It's kind of related, mine, I think. So mine goes to the Toronto Police, who continue to, more than 400, no, 500 plus days since October 7th, allowed these anti-Israel protesters to block streets whenever they feel like it and just say, we're doing a protest. And that causes harm to people when you blockade a city. And, yesterday this happened again. We saw this really big group of anti-Israel protesters wearing their keffiyehs with their face coverings, trying to look all intimidating and
And
Hamas-like, in
green
my
green
opinion.
headbands, green
Oh, I didn't know
Hamas
there
style
was.
headbands. Yeah.
I didn't know there was actual. I mean, a lot of them are obviously pro-Hamas, but when they wear the headband, you can be pretty sure. So what they did was what they've done many times, which is block a big intersection at Bloor and Yonge, which is outside the Israeli consulate. And they could have done this on the sidewalk. There's lots of space there. They could have done this in a park. They could have done it in a public square, but instead they decided to shut down the street for a prayer. And the cops didn't do anything. There's cops there. They're just standing there as usual. And I've been spending a lot of time thinking about freedom of peaceful assembly because, of course, that's the charter guarantee. It's not freedom of any assembly; it's freedom of peaceful assemblies. And I think that protects every type of assembly, regardless of its content. So the fact that it's a prayer is not a problem. You're allowed to mass pray in public spaces. But if you're constraining and coercing other people, you're using force against them in the form of a blockade, you're not acting peacefully anymore. And some civil libertarians will argue, well, it's okay to blockade for a period of time. Some will say it's okay to block even for, weeks at a time, which I think is pretty crazy. And then it's just up to the judge to decide when it's gone too far. But that's just not a principled position here. So I think if you start using force against other people, freedom, according to the course, is the absence of coercion and constraint. Once you start coercing and constraining other people, you're interfering with their rights, and that's not going to be protected by Section 2C of the Charter. So, you want to march down a street, you want to go in a park and hold a mass prayer, be my guest, but I think this blockading needs to stop. And so my bad legal take goes to the Toronto Police, who have done very little to put limits on these really nuisance protests that are really blockades, not protests, and making life miserable for a lot of people and frankly intimidating a lot of people, which seems to be their point. So that's my bad legal take. Christine, why don't you tell us yours?
So mine sort of relates as well. All of these things are interrelated. So my bad legal take goes to the city of Hamilton for attempting yet another bubble zone. They're debating a bylaw to prohibit protests near places of worship and their facilities. And these laws have been implemented all over. They've sprung up sort of beginning in 2020. They kind of started applying everywhere. Before that, there really had only been bubble zones around abortion clinics for a couple of decades, but nowhere else. And then since beginning in 2020, they've been implemented near schools, hospitals, libraries, rec centers, and now places of worship. We were just in court in Calgary fighting the one near libraries and rec centers. And by the way, Marco Mendocino, who's now the Prime Minister's chief of staff, has even proposed bubble zones near politicians' offices. So the Hamilton law would be around places of worship. There are other cities that have things like this. Vaughan recently created a bubble zone near places of worship. And look, I want to be clear that I am very troubled when I see protests near places of worship. We've seen them near synagogues in particular, and I think that's what this law is aimed at. I think that is disturbing and terrible behavior. and worthy of us condemning and saying this is inappropriate and wrong. And there actually are criminal prohibitions on interrupting a service if a service is taking place. But I also think you should be able to protest near places of worship. You know, there have been mosques that have invited speakers who lionized the famous terrorist Nasrallah. There have been mosques that have invited very anti-Semitic speakers. You should be allowed to protest that. And you should protest that. I think that's worthy of protest, especially if you're a member of the Muslim community who says, I don't want speakers purporting to do this on my behalf. You want to be able to express your dissatisfaction with that, and that's a good thing. You know, there also have been protests, and I want to make sure I'm getting the facts right about this because there have been some, you know, inconsistent reporting about it. But there was a protest near a synagogue where the pro-Palestinian protesters who were doing this said that they were protesting an event taking place inside the synagogue, where they said it was not a religious service, it was a real estate event where land in the West Bank was being sold. And I'm not sure of all the details, but, you know, if that is the case, why should you not be allowed to protest that if you disagree with it? I think that, you know, sometimes it might be colorable that you're doing it for another reason and you're using this as the justification. But I think, you know, as a society, we probably want to know who these people are that would be willingly protesting a particular religious group so that we are aware of the extent of that viewpoint and can address it as a society. And I also think religious institutions and places are not immune from scrutiny if they're doing things that are worthy of criticism and protest. So that is what I think of the Hamilton proposal and the existing bylaw in Vaughan, and I think that they could be subject to a constitutional challenge. It would all come down to the Section 1 justification, but I don't like seeing this kind of thing, and I don't like how it's spread so rapidly since the pandemic. Joanna, what's your bad legal take this week?
My bad legal take goes to the University of British Columbia Okanagan's student union, which initially blocked a conservative club from forming while a liberal club was allowed to exist, showing their double standard with political expression. Look, universities should be places where you are exposed to many diverse viewpoints. Like, that's the point of university, where you can express your viewpoint, you can be exposed to different viewpoint, you can debate people with different views, especially different views that you may find challenging or disagreeable. That's like the rite of passage. And the student union had rejected ratifying the club based on concerns about the political stance of the party. It was not connected to any specific or feared actions of the proposed club itself. So it was clearly just engaging in basic viewpoint discrimination. They put out a statement that they were concerned about balancing freedom of expression with our responsibility to foster a safe and welcoming space. But free speech and a safe and welcoming space are not goals that are in conflict. Inclusion means allowing all political viewpoints to be represented. When I went to university, there was a communist club. I think there was some club that was rumored to be funded by the CCP, which maybe raises a few other questions. But the point is that there were fringe viewpoints, and a conservative club does not represent a fringe viewpoint, to be clear, but that's okay. The student union suggested that the conservative club should take a more neutral stance in order to be approved, which is unacceptable, would set a horrible precedent that would effectively neutralize meaningful discourse. Now, the good news, the happy outcome, is that they've reversed their decision and they have allowed the club to be ratified. But the whole nature of the fight and the demands that they profess to put up really leave a bad taste in your mouth and really shows you the inherent suppression and censorship instincts of those who have no value for viewpoint diversity. So, bad initial instincts and good job on pushing this club through.
Yeah, for sure. Reminds me of my days covering universities for Maclean's. The student unions will never fail to surprise you in their authoritarian natures. That's it for the show. We hope you'll rate us, review us, and subscribe if you haven't already. You can support our work by going to the CCF's website and donating using that blue button if you can, or also just by following our work by going to our website and signing up for our Freedom Update newsletter. The CCF is a nonpartisan legal charity funded by your donations, so please do donate if you can. Thanks for listening.